My bill, House Bill 5795, kind of was born from conversations that emerged from the First Lady's initiative around sexual assault on campuses. And as staff and representatives who were part of the summit, as well as additional things that have occurred after the initial summit, there was a lot of conversation around Title IX offices and the variety of different campuses and what they do and how they are structured, how quickly they might do investigations and so forth. And I think there was a sense that all those institutions were at a variety of different levels. And then you would hear oftentimes complaints from survivors about how timely the reports were, was there adequate investigation done, and so forth. And so from that conversation a little while back, we began to have a conversation in my office around creating an ombudsperson for higher education and Title IX. So if a person on a campus felt like their campus was not treating their Title IX conversation with the due diligence that should be, that there should be somebody at the state level who could help them. When we first started the conversation, I think we looked at the traditional ombudspersons that are already in corrections or at the veterans home, and it became very clear that that was not what we were looking for, because those offices have a purpose to do investigations when the Title IX is actually occurring and that investigation is already occurring on the campus. And so, you know, I've now moved away after talking to a variety of stakeholders and so forth, away from calling this an ombudsman. We probably will come back with additional language, Mr. Chairman, to probably call this an Office of Title IX Compliance or something of that sort, to really give a better sense that this is not somebody who is overseeing all of these institutions, but there is a resource that is available at the state level. Obviously, there is availability at the federal level, but there's a disconnect if you were asking a student to try to call Washington, D.C. to get help, and so why not have something at the state level? So at this office, as it's being looked at and as the conversations have occurred over the last few weeks, we've really focused on really two things. One is a set of using best practices and helping institutions where they can actually call this office and say, hey, this is material that we want to create. These are different types of training we'd like to do. Can we use you as some level of expertise? Currently, right now, we have the state police doing grants towards sexual assault on campus. We have the board within DHHS, but we want to be able to put it in one place. But also, so that's one function of this office. The second function is to serve really as an advocate. If there is a question of a survivor on a campus, that they can be able to go to the state and find out what all their options are. If they aren't getting material back from this institution on a quick enough pace, that this office would have the ability to go forward and ask the individual institution about the status of the investigation and what is happening within that investigation. So this initial draft that you have in front of you, or the first version, we now have a number of changes that we're going to be making. At least we would encourage those changes based on dialogue and discussion. I just wanted to kind of talk about a few of those potential changes based on the feedback now that this bill has been introduced, and now that we've gotten a number of higher education institutions as well as domestic and sexual assault organizations to look at this. The first thing that they had asked us to make stronger in this legislation, we would hope that you would consider, is making sure that we protect the privacy of the survivor and make sure that whatever is happening within the office here is protected during any type of ongoing litigation and investigation. Right now we have within the Children's Ombudsman certain protections that if conversations are happening, that those cannot be used in a court in a different type of proceeding. And so there is language there that we would want to continue and bring over to this section to protect those survivors. The second thing we wanted to take a look at is make sure that all communication, as I mentioned, is completely confidential. That is not open to FOIA. We've already put that language in this initial part of the bill, but there are some additional language that has been recommended by others. The third is that we would like to make sure that there is collaboration between the Michigan Domestic and Sexual Violence Prevention and Treatment Board, this office, which is actually in the Department of Civil Rights, and then any outside organization that's doing work in here. And so we'll want to make that explicit here. And then we want to make sure from the university standpoint that whatever is being done in this office does not infringe on their obligations to the federal Title IX office on the federal level. And so they've encouraged us to add some additional language that just clarifies that. We think it already did that, but they have suggested some additional language that would happen there as well. So as we continue those conversations with different providers as well as different stakeholders, we'd hope to provide you a substitute in the next week or so to take a look at all of these ideas and put them into one area. But we want to make sure in the end that there's a resource for survivors at the state level, that we want to make sure that the state level is providing resources back to institutions and serving as a resource. And then in the end, all through this whole process, we want to ensure that the privacy is kept amongst survivors as they work with this office.